Kia ora, Kiri, good morning. It's really nice to see you. Thank you for being with the committee. You know how this project works. I'll hand over to you for the 10 minutes to provide us with your presentation. Sorry, you're on mute, mate.
It's like my uncles reminding me they're on mute. Tēnā koe, James, o tira kia koutou ngā memo tēnei komiti. He uri tēnei o Ngāti Rangi Nui, Ngāti Rangi Tūwhare Toa Te Raroa Hoki. My name is Kiri Allan, and I'm opposed to this bill because it is a simple abomination. It seeks to erase Māori from our own history books and in our own lands. This is not just about erasing 50 years of treaty jurisprudence that has evolved since 1975. This is a bill that is about scrubbing us from history. This bill highlights a constitutional crisis. Te tiriti o Waitangi is a fundamental tenet of our constitution and is the fibre of our nation that weaves us together. But this bill is a result of coalition negotiations. This bill is a representation that up for grabs in coalition negotiations are the core components of our constitutional arrangements. This is an unjustifiable decision by those seeking power to enable the unwinding of the constitutional status of Te Tiriti through this bill and in this manner. Our constitution underpinnings should not be considered that cheap by those vying for power. Further, the bill erodes and undermines every undertaking made between the Crown and Hapu and iwi, right from the promises made in 1840 to the more recent promises made by the Crown to Hapu and iwi through the treaty settlement process. Despite poor attempts to preempt judicial inquiries out the wazoo into treaty settlements, this bill will simply open them up. It will simultaneously breach whilst purporting to protect settlements in the same breath. Every single treaty settlement contains an apology by the Crown to Hapu and iwi for the wrongdoings of the past and an undertaking to work together to forge a treaty-based partnership moving forward. The mere action of allowing this bill to come into this House is a breach of those promises. Now, the Crown may wish to wash its hands of Te Tiriti because of the treaty settlements process, but the settlement process was not a precursor to the eradication of Te Tiriti o Waitangi from our constitutional framework. Now, there are two ways to mobilise people in politics: provide a vision based on hope, or create an environment of fear. This bill is a populist bill that strikes at the heart of fear. This bill is intended to incite the fear that Māori gain from Te Tiriti in ways that other New Zealanders don't. But that is a simple lie. It denies the history of our nation. It denies the fact that everyone has a place in this country because of Te Tiriti o Waitangi. And no one loses because we are a nation that honours our history. There have been sustained calls from proponents of the bill that there needs to be a conversation about what the treaty principles are. The reality is that this has been a sustained conversation about Te Tiriti since 1840, and an independent commission of inquiry was established in 1975 specifically to inquire into what Te Tiriti means in a contemporary context. The architects of those bill may find those interpretations by both the courts and the tribunal as an inconvenience to their ideology. So they have crafted their opposition in part on the basis that Te Tiriti creates legal uncertainty today. Now, the architects of this bill may find legal history in this country inconvenient. The minister responsible for the bill 2 days ago stating that Hapu and iwi lack sovereignty to enter into a treaty, despite the fact that Hapu and iwi had signed Te Whakaputanga, crafted by Busby, asserting that Māori were a sovereign people. As the Cabinet Manual states, a treaty is a written agreement between states that creates obligations for those states that have expressed their consent to be bound. The Crown expressed its consent to be bound by entering into Te Tiriti o Waitangi. It is a privilege to exercise executive decision-making powers, and with privileges comes responsibilities. As the Minister of Conservation, I had the responsibility to ensure that Section 4 of the Conservation Act, that requires that the Act is to be interpreted and administered as to give effect to the principles of the Treaty of Waitangi, was complied with. There is both a principled and practical history to such clauses. The Department of Conservation administers 1/3 of the landmass in Aotearoa, and, for example, this comprises lands that were taken by raupatu, illegal land confiscation. It includes the administration of taonga, birds, trees, fisheries, kōiwi such as whale bones, and much more. Māori, hapu and iwi were guaranteed te tino rangatiratanga o ō rātou whenua, o rātou kāinga, me o rātou taonga katoa. The English text guaranteed the full, exclusive and undisturbed possession of their lands and estates, forests and fisheries. The Crown has accepted that raupatu was a breach of Te Tiriti o Waitangi, lands that were taken wrongfully and, to date, are yet to be returned. The Crown, if the bill was to be enacted, Section 4 would be stripped of any meaning and effect. It becomes a hollow and meaningless clause. Now, this bill is but one part of a comprehensive strategy being deployed by this government, led by its coalition partners, to eradicate Māori as part of our legal and cultural landscape. Whether that is through our reo, evolution of resources to enable equitable outcomes for Māori, or the Treaty Clause Review, the Regulatory Standards Bill, and this bill's express intent to eradicate, for all intensive purposes, Te Tiriti o Waitangi. For the reasons set out, I urge all members to oppose this bill and make the recommendation that all legislation contain a clause that each act shall be interpreted and administered as to give effect to Te Tiriti o Waitangi. I'm happy to take questions.
Kia ora, Kiri. Thank you for your presentation this morning. I'll offer the first question to Kusha because we didn't get to it before. If you don't have one, I'll go to Takata first.
Tēnā koe Kiri, pai te kite atu i a koe. Our last presenter came from a very different angle to you, but she kept referring to Labour as the government. In your opinion, what are some of the most positive initiatives that have come out with regard to treaty principles in the past? And how do you see the damaging effects of what could happen now?
Well, Te Tiriti is about a partnership in some regards, right? And so, for example, I can use many examples, but Jobs for Nature was a great initiative that enabled Māori to be able to work their whenua. It enabled Māori to be able to reconnect with maunga, awa, because there had been that disconnection for many years. It enabled the devolution of resources to initiatives like whānau ora. Te Tiriti o Waitangi has created many positive implications for our people, all New Zealanders, and this bill is an absolute slight on that history.
Kia ora, Takata, and then we'll go on from Todd.
Tēnā koe, kiri ngā mihi nui a kia koe me o mahi huhua I roto I nei tuāhuatanga. There just is an apparent lack of understanding amongst the people who support the bill. You and I will know that it's called a treaty. It's the Treaty of Waitangi, not the Contract of Waitangi, because treaties are the things that bind sovereign nations. So the sovereignty of Te iwi Māori shouldn't be in question. But it seems to still be the case. And so the treaty is entirely constitutional in nature. So what in your opinion, what sort of jeopardy does this bill present to the erasing of Te Tiriti o Waitangi I'm talking about? What sort of jeopardy does that present to the constitutional rights of all New Zealanders to be in New Zealand?
Te Tiriti o Waitangi, as I said, is a part of the fibre of our nation that weaves us together. Now, to enact this bill would eradicate the undertakings and the promises that our forebearers made to each other. It undermines and unwinds the constitutional status by dint of a coalition-agreed bill. Those protections afforded to our constitution simply cannot be unwound because of political posturing.
Kia ora.
If it's
Very quick question, yes. Thank you for presenting. Todd Stevenson here. Just at the end of your submission, you said legislation going forward should use the term give effect to treaty. So are you saying that should be different from the principles of the treaty? I just want to see if you actually a distinction.
I'm saying that each bill should give effect to Te Tiriti o
Okay.
Waitami.
So not just the principles.
Te Tiriti o
Yeah.
Waitami.
Okay. Thank you. Just wanted to check that.
Good. Thank you, Kitty. Thank you for joining us this morning. It's really good to see you again. Hope you're well, and we appreciate you being here.
Kia ora, James.